All right, if you are prepping for the bar, there is one tool you absolutely positively need to have sharpened in your litigation arsenal, and that is summary judgment for the plaintiff. I mean, getting this right can literally win your case before it even properly starts. So in this explainer, we're going to master it.
Okay, so here's our roadmap for today. We're going to start with the foundation, which is Rule 292. Then we'll really unpack the two-part test that you'll have to argue. After that, we'll look at it from the other side, how to resist judgment. Then we'll get into the nitty-gritty of the rules of evidence, and finally, we'll cover the crucial role of judicial discretion. Let's jump right in.
First up, the foundation. To know when to strike, you have to know the rule that gives you the power to do it in the first place. And for summary judgment for the plaintiff, your starting block, the one you need to remember, is Rule 292.
So what are we really talking about here? Well, at its heart, summary judgment is all about efficiency. It is an incredibly powerful tool for ending a case early when, let's be honest, the outcome is pretty clear. It saves everyone the time, the expense, and the stress of a full-blown trial. It's really for those cases that are, frankly, just not fit to proceed.
So what's the trigger? What kicks this all off? For your exams, please commit this to memory. It's found in the Uniform Civil Procedure Rules, the UCPR, specifically Rule 292, Sub-Rule 1. That rule is your gateway. The moment the defendant serves that notice of intention to defend, well, the clock starts, and you as the plaintiff can make your move.
Okay, so you filed your application under Rule 292. Now we get to the core question. What do you actually have to prove to convince a judge to end the case right then and there?
This right here is the heart of it all. This is the two-part test under Rule 292, Sub-Rule 2. You have to nail this for the exams. First, you have to prove that the defendant has no real prospect of success. And second, you have to show that there is no need for a trial. And remember, it's not one or the other. You absolutely must satisfy both of those limbs to succeed.
Understanding the history here is really key to understanding the modern test. The old test, from the General Steele case, it set an incredibly high bar. A defense had to be so obviously untenable that it cannot possibly succeed. Just a ridiculously high standard. But the modern test in UCPR 292 is different, and this was confirmed in big cases like Deputy Commissioner of Taxation v. Salcedo. The phrase "no real prospect" actually lowers that bar. Now, don't get me wrong, it's still a substantial hurdle, but the focus is now on a realistic assessment of the evidence, not just a quick glance at the pleadings.
Okay, we've covered the plaintiff's attack. Now let's flip the coin. Imagine you're the defendant, and you've just been served with a summary judgment application. What's your playbook to keep your case alive?
This quote from Lord Hope, which Queensland courts have applied in cases like CSR Limited v. Carceron, this is your guiding principle as a defendant. This should be your mantra. It frames your entire objective. Your one job is to convince the court that this case is fit for trial, that there is a real question that needs to be decided.
So what does that look like in practice? Well, you've got several strategies. You can argue the defense isn't fanciful, that it actually has some substance. You can point to genuine factual disputes, especially where a witness's credibility is key and really needs to be tested at trial. You can show a need for discovery to get more evidence. And here's a critical one. Seek leave to amend your pleadings. As cases like Lily Pond Construction show, a court is pretty unlikely to grant summary judgment if a simple amendment could create a triable issue.
Okay, let's move to the rules of engagement. A strong argument is completely useless without the proper evidence to back it up, right? So how do you actually put your case before the court in a summary judgment application?
So the key concept to grasp here is the shifting onus, which was confirmed in cases like QLD Pork Proprietary Limited v. Lott. Think of it like a rally in tennis. The plaintiff serves first, they present evidence to make a prima facie case. Once they do that, the burden shifts. The defendant then has to return serve with their own sworn affidavit evidence showing there's a real issue to be tried. Just baldly denying things in a pleading, that's simply not going to be enough.
Right, let's break down the procedural rules for evidence under UCPR Rule 295. This is the nuts and bolts. As a default, Rule 295 Sub-Rule 1 says all evidence must be by affidavit. Simple enough. What if you want to cross-examine? Well, under Sub-Rule 4, it's pretty rare and you're going to need the court's permission. And please pay very close attention to Rule 295 Sub-Rule 2. If your affidavit contains statements of information and belief, you must state your sources and your reasons. The case of Vivlios v. Westpac is a perfect cautionary tale. Get this wrong and your evidence could be thrown right out.
And finally, let's talk about the final hurdle. Even if you, as the plaintiff, have a rock-solid case and you believe you've satisfied that two-part test perfectly, there is one last very powerful factor you must always consider.
This is a vital takeaway for your exams, and it was established in huge cases like Wilmot v. McLee. Look at the wording in Rule 292, Subrule 2. It says the court may give judgment. That single word, it's everything. It means that even if you satisfy both parts of the test, the judge retains an ultimate discretion to just say no and let the case proceed to trial if it's in the interests of justice.
And finally, let's just cover a few key nuances for your exams. These are important. First, partial judgment is possible. You can win on just one part of your claim, not necessarily the whole thing. Second, be very aware of costs. Under Rule 299, Subrule 1, a weak or ill-conceived application can leave you paying the other side's legal fees. Ouch. Third, what about delay? Well, cases like DCT v. Gleason show it's relevant but not necessarily fatal to your application. And finally, minor pleading defects won't always save a defendant if the core of the case against them is clear.
So we're going to leave you with this final thought to ponder for your exams. We know the test is no real prospect of success, but cases have also talked about defenses that are, weak or even shadowy. So given the court's ultimate discretion, where exactly is that line drawn? How weak can a defense be before it crosses the threshold from merely unconvincing to having no real prospect at all? That right there is the fine judgment that you will have to make.